Telephonically, are you, sir?
I am here.
Very good. And, sir, you want me to preside over the meeting as you're on the telephone? Is that
I do. I think it'll run smoother with you being there in person.
Okay, thank you. Thank you. I will do that.
Mr. Vice Chairman,
Sir.
and the advice of counsel, I am instructed to make a statement and exit the meeting and allow other discussion to take place in return for motions and a vote. So if I may go ahead and make my statements, I would very much appreciate it.
Well, okay, we haven't got to it, but go ahead.
So are we discussing item 1 first?
Yes, we're at item 1, discussion, approval, disapproval, to reconsider agenda item 4 from Pinal County Board of Supervisors meeting February 1, 2023, regular meeting. This request is made in accordance with the general board meeting rules of order, specifically 4C. This is from Steve Miller, so go ahead, sir.
Okay, well, before I get into a larger discussion why we should not release the report, I'll speak for on a couple practical reasons. First, at least 4 members of this Board of Supervisors may be rebuttal witnesses, but I cannot get into attorney-client conversations and evidence. So at least 4 of us and potentially 5 are going to be witnesses in this case, and for that reason alone, we should not be voting to release anything with respect to this case. The release of this report could harm the value as witnesses, impartiality, in defense of the county, as well as be a potential violation of the duty to cooperate with the insurance pool. I have delivered a paper to the county attorney. It appears that statements from the report may have made it outside exec session. So that is something they're going to handle according to their regular protocols. This board has adopted rules governing the conduct and procedures for a particular agenda item. A letter is required to be delivered within 24 hours of board action on a vote by a member on the prevailing side. Does the clerk have that letter?
Yes, Supervisor Kavanaugh. Supervisor Miller submitted an email to me yesterday, which was Thursday, and that letter was submitted at 9:29 a.m.
Okay.
I'm sorry, 8:29 a.m.
And so is that a letter or an email? Is it the proper form?
It is an email.
Okay. Mr. County Attorney, is that the proper form?
Mr. Chairman, Supervisor Kavanaugh, I would believe that an email would suffice as a written notification. The rules do say a letter, but I think, we would be splitting hairs to say that an email requesting the same, other than being put on letterhead, is any different.
And if I can just add to that, in the email it does say pursuant to this letter.
Okay. And so the published purpose of this meeting is to determine the merits and law regarding the release of work product report conducted on behalf of the county by a contracted law firm who in turn hired a contract private investigator. I would ask the chairman or vice chairman to remind the board that we would narrowly focus on our discussions of the agenda item published in our public meeting notice and limit questions to whether the report can lawfully be released, whether it is subject to public records request, and the merits of not releasing the report to protect the county from financial harm. And do we have an attorney present that would be able to give us advice in exec session regarding this release?
Vice Chairman McClure, from my knowledge, I do believe Mr. Jellis will be available telephonically.
So I would move that we go to exec session for advice.
Is there a second?
I'll second the motion into e-session.
We have a motion, a second. In favor?
Aye.
Opposed? Nay.
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 3-1. Mr. Miller?
Mr.
I
Chairman?
voted yes because I seconded it, but
Well,
it's 3 nays.
Mr. Chairman, just for point of clarification, and maybe this is a question to Supervisor Kavanaugh, requesting executive session on which item? Was it both items or just item one for your ability to go into executive session or for the privilege of waiving it? I just want to be clear for the record.
This would be both.
Both? Okay, thank you.
we've already had executive session on this, and so we have 3 nays. We have 1 aye. Motion fails.
Okay, thank you. So, under 38-431, disclosure of executive session information pursuant to this section does not constitute a waiver of any privilege, including the attorney-client privilege. Any person receiving executive session information shall not disclose that information. It goes on. And during our February 1st meeting, we had an executive session where Attorney James Jellison was present to give advice. Mr. Jellison was limited in his capacity to give advice because he is hired to represent the board exclusive of me and could not provide some answers. I can't disclose exec session items. But subsequently, our discussions of the release of this report, in the discussions of the release of this report, we violated exec session. We've asked other board members to reveal attorney-client privilege conversations and legal strategies in place to defend the county and the individual board member. And the board has prompted me to reveal potential evidence to refute claims made in the report, setting up what appears to be a conflict. So again, I would ask the chairman to closely follow board rules and law when discussing this matter. There was a question asked last week about the apparent reason my attorney may have rejected the opportunity to view the report. And it is because he likely knows that it's not a government record. It's not subject to a public records request. And perhaps by receiving it would infer that privilege no longer applies. I'm not obligated to disclose whether I've had specific discussions with my attorney on the matter, as under Arizona 502 Rule, I think 1 states attorney-client privilege means the protection that applicable law provides for confidential attorney-client communications, and work product protection means the protection that applicable law provides for tangible material or its intangible equivalent prepared in anticipation of litigation for trial. I think I covered a minute ago, the release of this report could harm the effectiveness, value, variety of things, because I believe at least 4 and perhaps all of us are going to be witnesses in this case. The release of this could be as well a potential violation of the duty to cooperate with the insurance pool. In Carlson v. Pima County, it states that you can't, essentially, if you can't personally swear to the facts contained in a document, it may not be good to release it because clearly under law, the document we're discussing is not a public document subject to disclosure. When deciding whether or not to release this report at all, we should be instructed by the case of Carlson v. Pima County, 594 P2D 1034. In this case, a public records request was fulfilled by the Sheriff's Office. The Arizona Court of Appeals found that the offense report was a public record, which was required to be kept and further required to be made available. The ARS 39-121 deals with some of this, but that doesn't apply to this report. The first statute provides that public records and other matters in the office of any officer at all times during office hours hours shall be open to inspection by any person. The report we're talking about today is not held in a government office, is not held by any officer. This report is held by an attorney. The fact that we are having a discussion of a vote to waive attorney-client privilege and work product privilege firmly establishes that we acknowledge that this report is not a government record. That is not in dispute. The next question for us to examine is whether or not this report is a public record required to be kept under 39-121. And that's easy to answer, is we do not keep the record. The record is kept at all times in the hands of an attorney. From time to time, the board has viewed the record for informational purposes to be updated on the status of a claim, but it is clearly not a public record that is being kept or required to be kept. The next question is whether or not the report was made by a public official. We can be instructed by Church of Scientology versus City of Phoenix, 122 Arizona 338-594, and Little v. Gilkinson. ARS defines an officer as any person elected or appointed to hold any elective or appointed office of any body, and any chief administrative officer, head, director, superintendent, or chairman of the public body, and further describes the public body as the state, any county, city, town, school district, political subdivision, or tax-supported district in the state, any branch, department, board, bureau, commission, council, or committee of the foregoing, and any public organization or agency supported whole or in part by funds from the state of any political subdivision thereof, or expending funds provided by the state or any political subdivision thereof. So based on the law that I've read, we know the following, that this is not a public record. It's not kept by a public body. It was not created by a public person. And the attorney's office that created this record is not a public body and is not charged with a public duty as found in ARS 31-101. Arizona has a Public Records Act, but the Arizona court chose to cite the Freedom of Information Act, providing that information shall be made available to the public with certain exceptions, including investigatory records compiled for law enforcement purposes, but only to the extent that production of such records would interfere with law enforcement. And then B is the important one. The exception is deprive a person of a right to a fair trial or an impartial adjudication. It is important to note that the Arizona Court of Appeals did not find that either the preparation or the release of the report involved any malice or intentional defamation. The court wrote in an opinion regarding 39-121, and even though that a normally public record subject to the official discretion even though that a normally public record be subject to the official's discretion to deny or restrict access where recognition of the interests of privacy, confidentiality, or the best interests of the state in carrying out its legitimate activities outweigh the general policy of open access. That is for a record that would
Mr.
normally
Chair.
be.
Supervisor Goodman.
If I might, you're reading some things that, we've already received counsel.
Well, no, Mr. Chairman, I would ask that I be allowed to finish, and the counsel was given to us is contradicted by.
I'm not following that, to be honest with you.
Well, then the attorneys can look it up,
But with what you're talking about, I know for a fact that I've been investigated because of allegations that have been made public through investigations on some allegations on particularly pavement on my driveway using the resources from the county. Now, that may be a little bit off, but the point is that report was made public. So if you're making those kind of arguments, in my opinion, it was an internal investigation, just much like the allegations and everything that you did.
Actually, now that's where we have to correct this, because this was not an internal investigation. The internal investigation you're talking about was done by the county attorney's office. The report that was done here was done by an outside counsel.
Mr. Volkmer, I'm sorry, gentlemen. Yeah. Mr. Volkmer, please.
I'm going to have a question, but I think Mr. Volkmer might
Forgive
answer the
me,
question I'm thinking.
Mr. County Attorney. My attorney advised us finish this up and not be a part and not be involved in discussions. I think it would be appropriate just to allow me to finish, and then.
I have to correct one thing because you've repeatedly made a false legal statement. You're misleading the board. Jim Jellison, when he performed this activity, was under my authority, so it was an official capacity. I am an elected official that is specifically there. He was acting in that capacity because I could not do so because the allegation was against one of my clients. So that is not an accurate statement, and that needs to be clarified. I cannot allow you to continue
Okay.
to make a false statement to the
Well,
board.
I'm not a lawyer, and these are the
But
items.
you're acting as one.
No, I'm not acting. I'm
You
not
tried
giving
to.
anybody advice. I've done the best I can to research this issue. Then these are what I have found that would support not releasing this item. So as we consider the release of this report, is there motive of malice or intentional defamation? This is not an internal, in my opinion, and based on my research, an internal HR investigation for which we make a public record.
HR has no policy in holding this back. We've determined that last week.
Would you allow me to finish?
Sure.
Thank you. By releasing this report through a public records request, risk harming the rights of litigants to the case. There are 3 litigants, not 2. If we release the information concerning one plaintiff that is harmful to another, and this release wasn't for a clear legal purpose, we have to examine whether the county would be responsible to the harm to one of the other litigants. Based on my research, this is not a public report. It's not subject to public disclosure. I have the 2 letters here that were delivered by 2 different attorneys who have come to the same conclusion. And so the board was, I think, wise to allow 15 days for legal issues surrounding the release of the report to be more thoroughly vetted, and I would recommend keeping this policy.
It was just a clarification. It wasn't a policy. It was a suggestion by you in a motion.
Well,
Just to be
that's
clear.
what we voted on.
Just to be clear.
Yeah. So that, I think, is about it. Let me check one more thing. And I've delivered to the county attorney a complaint that in the aspects of the report and discussions of the case were released in a public meeting in violation of our executive session rules. And I think that to properly investigate the release of the information, it would be wise and necessary to hold off on the release of the report. I think I referenced the supervisor asking me a specific question that may have came from the exec session, as well as information that's found itself out into the hands of apparently the plaintiff. So I think in the interest of making sure we have a clean investigation, it would be wise to hold off until the 16th, as we originally voted, to wrap up any necessary investigation. Thank you.
And you're recusing yourself for item 1. Are you also recusing yourself for item 2?
I'll be coming back in for the vote, but I can't be a part of this discussions.
All right. Okay. So, Mr. Volkmer, you have questions. I see question marks popping out of your head here. I can read thought bubbles like in the comics. It's amazing.
So what the board has before it is, at this point, just agenda item 1, which was the request from Supervisor Miller being on the winning side of a motion for a reconsideration. Supervisor Kavanaugh has indicated publicly, you all heard it, that he does not want to be part of the discussion. He wants to be part of the vote. I'm not sure practically how that happens. What I would suggest is if there is discussion this board wishes to have, that it would proceed now, and then I would ask or direct I'd ask the board to direct Madam Clerk to perhaps knock on the door to bring him back in to vote. I just don't know any other way practically we can.
To vote on this item, to vote on item 1.
Right. I mean, if there's discussion, I would suggest discussion now.
Okay.
And then if there is no discussion, that a motion either be made to approve, disapprove, or continue. And then once it is moved, once it's seconded before the official vote comes, I think you would invite Supervisor Kavanaugh back in for the official vote.
Very good. Thank you. Is there any discussion here from the board? Supervisor Miller.
Thank you, Vice Chair McClure. Just a so I'm the one that requested this. You want me? Should I keep talking or not keep talking? What am I supposed to do here?
Well, I don't understand what's going on here now.
There's no prohibition on you proceeding.
Okay.
So, my understanding of the original motion was my interpretation that it would be released what would be the morning of the 15th. After some discussion, I reached out to the clerk of the board and asked her to validate what was actually said in the motion. The motion indicated after the 15th. So I would not have seconded it if I thought it would after the 15th. I thought it was the morning of the 15th that it would have been released, before our meeting. So hence the reason that I've asked for a reconsideration.
Very well. Is there any other discussion? So, under advisement, is there a motion this time?
Mr. Chairman, at this point in time, for any action to go further on item number 1, there needs to be a motion and a second and so forth.
Right. So is there a motion for item 1 here?
So I'd like to make a motion for reconsideration.
Second.
So we have a motion and a second. Those in favor?
Aye.
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 Opposed?
Nay.
4-1. Motion passes. Very well. So now we move to item 2. Item number 2 is discussion, approval, disapproval to waive attorney-client and work product privilege regarding the report of administrative investigation of complaints made by Amanda Stanford and Garland Shreves dated August 27, 2022, and direct the report to be released subject to any necessary redactions. Is there any discussion? Hearing none, is there a motion?
Mr. Chair, I'd like to make a motion that we approve item number 2 as presented.
I have a motion. Is there a second?
Second.
I have a motion and a second. Those in favor?
Aye.
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 Aye. Opposed?
Nay.
4-1. Motion passes. With that, we're adjourned.